Hey, good afternoon. TikTok, YouTube, Facebook, LinkedIn. I'm Brian Manning, and you're watching the Asylum Answer Show. I'm going to answer your questions about Asylum. So go ahead, start leaving them in the comments. Let me know what you want to know. Okay, what questions you have about getting asylum in the United States, because that's what I do. I'm a political asylum lawyer. My law firm is called Political Asylum Lawyers, and we help immigrants all over the country to secure their future in America through asylum. Okay. Doesn't matter where you are. We help people all over the country. We're based in Texas. We're based in Houston, Texas, but we have clients all over. We help people all over. So let me know what you want to know. I want to answer your questions today about getting asylum in the United States. Um, Aksan says, do you know anything about the UK? About UK? Nope, I don't. I can say that it's probably going to be somewhat similar, at least some of the main ideas in terms of applying or qualifying for asylum are going to be similar because most countries base their asylum systems off of the same international agreements, especially the UN Refugee Convention. So it's going to be pretty similar, but it's not the same. Definitely the mechanics, the logistics of like how do you apply and things like that are going to be, the timelines are going to be very different. But some of the principles that I talk about, Aksan, are gonna translate in terms of thinking about how to prepare. So on YouTube, go to my YouTube channel. All right, it's called Political Asylum Lawyers. Go to YouTube and search for Political Asylum Lawyers, and you're going to find some like detailed trainings, some full length hour and a half long trainings that are really detailed. They're going to give you all kinds of tips for winning your asylum case. All right. Let me know your questions, but before I get back to the rest of the questions, I'm going to just say a couple words. All right, about something. Again, I'm Brian Manning, and it's a pleasure to have you with us on the Asylum Answers show. So thank you for joining. Go ahead and start leaving your comments. Also, say hello. Let me know where you're watching from. I'd love to see where you guys are at. Before I get to your questions, though, can someone who's what happens if you are a dependent in the asylum case of your spouse, but then you get divorced? Okay, what happens? What do you need to do? So let me define a couple of terms. When I say dependent, I mean that you are either dependent in an asylum case is either a spouse or a child who is unmarried, meaning they're single, and they were under 21. They had to have been under 21 at the time that the principal applicant applied. The principal applicant is like the main asylum applicant. It's the person that is sending in the form and saying, my name is so-and-so, I'm applying for asylum. They're the principal applicant, okay? And so the dependents in the case, the spouse and the children who are unmarried and who were under 21 when the application was filed, they get asylee status through the principal applicant if the principal applicant wins their case. But if that qualifying relationship between the principal applicant and the dependent ends, then the dependent can no longer be a dependent because that qualifying relationship doesn't exist. So if, let's say, a married couple are together and one of them submits an asylum application and the other spouse is a dependent in a case, then what happens to that dependent if they get divorced? Because when they divorce, that qualifying relationship ends. So the dependent cannot get asylum through the principal applicant. Even if the principal applicant wins, the dependent is left in the cold. They don't have any way to get asylum through the principal applicant. Okay. So what can they do? Well, they can apply for asylum on their own as a principal applicant. Now, the main question that comes up is, okay, well, wait, what about the 1-year filing deadline? Because for many people, they'll be waiting, they'll apply, 6 months, 8 months, 10 months after coming to the United States. And then they're waiting for a long time for their interview. They're well beyond the 1-year filing deadline. So what happens if that spouse who got divorced, who was the dependent, if they now try to file as a principal applicant, is this 1-year filing deadline going to bar them? Is it going to keep them from getting asylum because they're filing past the 1-year filing deadline? Well, thankfully, this scenario falls under one of the two sort of categories of exceptions to the 1-year filing deadline. Okay. And the idea here is, well, we shouldn't penalize someone and not give them any chance to get asylum just because they got divorced. Like they thought that they were going to be covered and have a chance to get asylee status through their spouse, but then this changed, right? So we don't want to just say, no, 1 year filing deadline, you're past it, therefore no chance for asylum. Instead, what the asylum office will do, and or the immigration judge, if you're in immigration court, will do is they'll say, okay, you can apply on your own, and you will not be barred by the 1 year filing deadline if you file for asylum within a reasonable time of the qualifying relationship ending. So in the case of a divorce, what is this incident or this thing that constitutes the termination of the qualifying relationship? Well, it's like the day the divorce decree becomes final. Okay. This is also relevant if someone dies. If your spouse dies and they're the principal applicant, you can't get asylum through them because they were the principal applicant. You don't have an asylum case pending of your own yet, so you would have to apply as a principal if you want to get asylum. Okay. And so a second ago, I said that, okay, what the judge or asylum officer is going to do is going to say, okay, when you as the dependent, now you file as a principal applicant. The question is, did you file in a reasonable time after the qualifying relationship to the old principal applicant ended? What's a reasonable time? Well, we know that basically anything under 2 months will almost certainly be considered reasonable. That's good. Okay. But when you get past 2 months, when you get to 3 months and beyond, it starts to become questionable. Some judges or officers will say, okay, 3.5 months, 4 months, that's reasonable under the circumstances, but some will not. Okay. So the point is this: if you get divorced, or if your spouse, or if you're a child and you were included as a dependent in your parent's case, but then that parent dies, or even if they don't die, but if they just if they withdraw their asylum case, or that might work. Okay, but definitely if they die, you've got to file in a reasonable time. Okay, so any of you out there, I hope you're not going through a divorce. That sounds tough, but if you are and you're the dependent in the case, you need to think about whether you're going to apply as a principal applicant, because you're not getting asylum through that spouse or soon to be ex-spouse or now ex-spouse. If you in fact get divorced, you can't. Okay. So are you going to apply? And if so, if you're going to apply as a principal applicant, you got to do it quickly. I encourage you to do it within 1 month of getting the final divorce decree. Okay. And so that's the main thing, is you gotta apply quickly. Okay. Now, one more thing related to this to address is that when you're applying as a principal applicant, you've got to win on your own merits. Meaning the officer or judge who considers your case is not going to look at the case of your ex-spouse or deceased spouse or deceased parent and say, okay, well, they had a pretty good case, therefore that helps you, and so you'll win. That's not how it works at all. You have to meet on your own the requirements for asylum. You have to establish all the elements of asylum eligibility on your own, meaning you, not your spouse, not your children, not anyone else, but you have been, or there's a reasonable possibility that you will be persecuted in the future in your country because of the fact that you possess one of the 5 protected grounds under U.S. asylum law, protected characteristics. Those are your race, religion, nationality, political opinion, and something called membership in a particular social group. Okay. So you've got to apply, and you got to think about how you're going to explain your case. Okay. And how you're going to present the strongest case possible. So if that's you, if you're in a position where, you might end up getting divorced, you should talk to an asylum lawyer right away. Okay. We get that question quite a lot. And we've had people who have hired us in this circumstance where they get divorced and they need to apply on their own as a principal applicant. And so we help them do that. All right. By the way, if you want to talk to us about your situation, give us a call. This number above my head is what you should call TikTok, or YouTube and Facebook. The number's above my head. On TikTok, there's nothing above my head, but you can go to my profile, click on my name. It'll take you to the profile where you'll see the telephone number for our law firm. Okay. Give us a call and schedule an asylum strategy session. This is a consultation where one of our asylum lawyers is going to analyze your case. We're going to see what's going on, tell you whether we think we can help you. And if so, we're going to explain to you exactly how we're going to help you, like in detail. Okay. So give us a call. I hope you will. And I hope that we'll have a chance to talk with you to see if we can help you secure your future in America through asylum. Okay. Doesn't matter where you are. We help people all over the country. All right. And it doesn't matter whether your case is in immigration court or with USCIS. Doesn't matter whether you've already applied or you're just now thinking about applying. We help people in all those different scenarios. Okay. So call us now and schedule an asylum strategy session. All right. Okay, let's get to the question. Say hello. Let me know where you're watching from. Let me know what questions you have about asylum in the United States. All right. Let's see what's going on. All right. All right. All right. What is your RS on YouTube says, what is your prediction for interviews for people in the United States who entered on a visa and applied in 2022? If you applied in like November or December of 2022, then there is still a chance that you will get your interview sometime relatively soon in the next month or two. If that doesn't happen, or if you applied earlier than November of 2022, or if you applied in November or December and you don't get the interview in the next 2 months from now, then man, the chances I would say, unfortunately, for getting that interview within the next couple of years are very, very low. Okay. Because the way that USCIS schedules cases now is when someone applies, they try to schedule them right away. Like they say, okay, who's applying now? Do we have spots to put them into right now to get their interview done like within the next 2 months? And if that doesn't happen because their priorities are elsewhere, because at that moment when you applied, they had to assign 90% of the workforce to credible fear interviews, and so they couldn't schedule many affirmative asylum interviews, and therefore you go in, if you don't get in those first few months, you can end up in the backlog, that really, really long backlog, and it could be years, to be honest with you. Okay, if you get to 3 years, I would sue the government. Okay, I would sue the government to force them to give you your asylum interview. Okay, it's called a mandamus lawsuit. We love that. We love that kind of lawsuit. It's incredibly effective. We've been having success with it. All right. Usually, if the person's been waiting a long time and they sue, the government says, "Oh, you know what? We don't really want to fight this case out. If you promise to drop the lawsuit, take it away, we'll give you the interview, okay, and we'll give you the decision soon thereafter." So it's really powerful, okay, and it does not hurt your chances for success. It will not make the government mad at you or want to get revenge or take it out on you or look at your case in a negative light at all. Your asylum case, that is, the fact that you've sued, okay? So if you want to talk about that, call us, okay? Badru, thanks for your question. Why don't you send us an email about that since you're a client? We've got, so yeah, Gadarwag is watching from the Bronx, New York. Nice. Where else? Where are you guys at? What was that? Oh, that was an interesting question on TikTok. Let me go back to that. Oh man. So Sam, I think it says Sim says, my expedite got accepted, but no interview. 3 months have passed. What should I do? So it sounds like, I'm sorry to hear that. It sounds like you're saying that you asked that your case be expedited. I'm guessing because of urgent humanitarian concerns. And they said, yes, the asylum office said, okay, we'll expedite it. Yet here you are 3 months later, and you still have not gotten your interview. That's tough. I'm really sorry to hear that you're in this difficult position. Okay. So first of all, is that common that they say, yeah, we'll expedite it, but then 3 months go by and they haven't scheduled your interview? I would say, no, it's not that common. Usually if they say, yes, we're going to expedite it, you get your interview within the next month or two. 3 months is pretty rare. So what should you do? I would follow up. I'd go back to them, send an email and a physical letter and say, hey, on X date, you told me that you would expedite my case. It's been 3 months. Could we please go ahead and get this scheduled right away? I'm still in a difficult position. I would really appreciate if we could get this scheduled right away. Please let me know if you need anything further from me regarding this request. That's what I would do. Okay. All right. Okay, good question. From YouTube. On TikTok, go over to my YouTube channel. Go to YouTube and search for Political Asylum Lawyers, all right? And subscribe, okay? On Facebook, go to Political Asylum Lawyers and subscribe. That's where I've got all my best stuff, all my detailed videos with lots of tips, and I've got some full-length trainings that I think are going to really help you increase your chances for success in your asylum case. All right. So on YouTube, on the political asylum lawyers, we've got a question from Tamara who says, "Hi, we're watching from Florida. Hope all is well in Florida. I heard that you apply to asylum and withholding of removal at the same time. How does that work?" Um, yeah. So yeah, like there is no separate application for withholding of removal. What is withholding of removal? It only, first of all, it only has any significance or matters in immigration court for people that have their case pending with USCIS in what we call an affirmative asylum case. This doesn't come into play. This thing about called withholding of removal and something similar called protection under the Convention Against Torture, which is very similar to withholding of removal. These don't come into play at all at the asylum office. They only matter for immigration court. Now, the asylum application itself is called application for asylum and withholding of removal, right? And then also on the application form, there's a little box. I think it's at the top of page 4, where it asks. Well, the question says, "Hey, check all the boxes for any grounds under which you're applying," and it's the 5 protected characteristics that I mentioned earlier: race, religion, nationality, political opinion, membership in a particular social group. But then there's the sixth box that says torture convention. And that torture convention thing is very similar to withholding of removal. Basically, what it is withholding of removal and protection under the Convention Against Torture are avenues that can allow someone to stay in the United States if they're at real risk of being seriously harmed in their country, but there's some reason that they don't actually qualify for asylum. So to be clear, asylum is better. Asylum is pretty much permanent, and it leads to a green card eventually, and that can lead to U.S. citizenship. So asylum gets you on the road to citizenship. These other things, withholding of removal and protection under the Convention Against Torture, don't lead anywhere. Basically, the judge is just like, okay, you can stay here and you get a work permit, but that's it. It doesn't lead to a green card. Also, you cannot bring people to the United States based on that status, as where with asylum you can. For asylum, you can get asylee status for your spouse and your children if they're already in the United States, or if they're abroad, you can bring them here on that basis, and they will have asylee status when they enter the country. So asylum is much, much better than these other things. So why would you be applying for these other things? Well, because there's some cases where you might not qualify for asylum, but you do qualify for these other things. So a really common example is if the judge is convinced that you're going to be harmed, but it's not on account of a protected ground. Like if it's just about money, but the judge is like, "Oh, these guys from the government are, corrupt, and they're targeting you, and they've threatened to kill you, and they've tortured you, and they're threatened to do it again or kill you," and the judge believes that, you can be allowed to stay here under these other or under the Convention Against Torture protection. So basically, the point is there's certain things, but you wouldn't qualify for asylum under that example because, in my example, let's say that the motivation has nothing to do with the 5 protected grounds. It's just like these corrupt government guys from the police just are extorting you for money. They didn't target you because of your race, religion, nationality, political opinion, or social group. None of that is in play. It's just pure money motivation. And so you wouldn't qualify for asylum because there's no nexus to a protected ground. In other words, the persecution is not on account of or motivated, at least in significant part, by the fact that you, asylum applicant, possess one of the 5 protected grounds. So you're not eligible. You're not going to win asylum. But if the judge believes that you're going to be tortured by the government, then you can get this benefit or be allowed to stay. Okay. Now, let me actually address that was just a sort of an overview of these other things, but let me address your question specifically. You're correct. There is no separate application form for withholding of removal. And for the Convention Against Torture, it's just a matter of checking that box on the asylum application that says torture convention. But like, you don't really have to worry about it if you already applied and you didn't check that box. At your individual hearing, you can tell the judge, like, "Judge, I would like, if you think I'm not eligible for asylum, then I would like you to consider me for withholding of removal or protection under the Convention Against Torture." And they will. It will be okay that you didn't check the box on the application. All right. All right. All right. That's interesting. Thank you for the question, Tamara. I appreciate it. All right, let's go over. Let's go to. Is this LinkedIn? Yeah, LinkedIn. We got Orlando MBA, who says, "Hello, Brian. For a person who's under removal proceedings, what is expected during the master hearing? My nephew he got a positive in the fear interview, and his master hearing is on August 21st. Good question. Thanks for asking. So let me define a couple of terms that Orlando has raised. Orlando, by the way, if you or your nephew speak Spanish, I have a YouTube channel in Spanish that I think you'll find helpful. If you go to YouTube and search Asilo Aprobado, you can find it's called Asilo Aprobado. Lots of trainings and detailed videos about all kinds of stuff regarding asylum. So anyway, defining a couple terms. So Orlando's talking about he called it a master hearing. There's different names for this hearing. Usually in immigration court, traditionally there have been two different kinds of hearings. The first one is called a master calendar hearing, or sometimes called just a master hearing. And then the next one, the other one, is called an individual hearing or a merits hearing. Okay. And the first one, those are all weird names. I wish they weren't called that, or they would change them. So the first one, this master hearing that Orlando's talking about, his question is, what happens at it? So it's basically administrative in nature. This is not the case where your nephew is going to need to actually explain his asylum case and be ready to answer a bunch of questions about it. Okay. Rather, this first hearing is administrative in nature. The judge explains what your rights are. They tell you what's going to happen in court. I mean, there's really there's one thing that's actually like matters and substantive, where the judge is going to review with you the document that is called a notice to appear. That's the one that the government gives to you that says, hey, we allege the following things. We say that you're not a citizen of the United States. You're a citizen of so-and-so country. You came to the United States without a visa on X date. Or you came with a visa and you're allowed to stay until X date and you overstayed that date. You don't have permission to be here now. And then there's a section of that same document that is called like the charge or charges, where they say, based on those facts up above, we think that you are deportable or eligible to be deported under this so-and-so provision of the law, which says if you don't have status or if you came to the United States without permission, you can be deported. And so the judge will go over that and say, do you admit those allegations? Is what the government is saying here true? And then based on that, if so, do you agree that you are eligible to be deported? Now, this is something that your nephew should discuss with an asylum lawyer to decide how to approach it. Usually, not always, there's definitely exceptions, but usually for most of our clients, we end up saying, yes, we admit those things and we concede or agree with this charge of removability, because they're usually true. But sometimes they make mistakes, or sometimes there's strategic reasons to fight it. But the next thing the judge will say is, okay, do you want to seek relief from removal? And if your nephew is thinking about applying for asylum, then this is where he would say, yes, judge, I have applied for, or I'm going to apply for asylum. I want to seek relief from removal in the form of asylum. The judge will say, okay. And the judge then may set deadlines. Usually they'll tell you when the next hearing is going to be. They'll schedule it right then and there, the date for the individual hearing. It could be a couple months after the first hearing. It could be a couple of years or a few years. It's impossible to predict that, unfortunately. So they'll tell you when that date is, and they may give you deadlines. They may say, listen, any evidence that you want me to consider in your case, you need to submit it to the court by a certain date. And they may make that date like 30 days before the individual hearing, or 60 days before it, or even 60 days after the master calendar hearing. If you have not yet applied for asylum, often the judge will set a deadline for you to file your asylum application, even that, and that deadline may be before your 1-year filing deadline date. So if the judge, it's very important to listen carefully. If the judge sets any deadlines for these things, you got to comply with them. You got to do it. Okay. So that's really important to keep in mind. But again, to be clear, this is not the hearing at which you got to be able to know all the details of your asylum case and be ready to explain it. That happens at the other hearing called the individual hearing. And that one, yes, absolutely. You got to be very, very well prepared for that. Okay. We help our clients prepare for that extensively. We do some pretty intensive practice and training to get ready to give them the best possible chance for success. By the way, uh, Orlando, have your nephew give me a call on LinkedIn. You should see that number above my head. On YouTube and Facebook, you'll see the number above my head. On TikTok, go to my profile and you'll see the phone number. Give us a call. Schedule an asylum strategy session so that you can talk with one of our political asylum lawyers about how we might be able to help you and win your asylum case. Okay. All right. David Bravo, hey David, good to see you, asks on Facebook, if a judge in San Francisco is new in the role about someone's asylum case, is that good or bad? David, do you mean like the judge was switched and now they're handling your case? Or do you mean they're a new judge, like they recently became an immigration judge? Actually, it doesn't matter what you mean, but because the answer is the same either way. It doesn't really mean anything good or bad. There's no way to really know. What I will say is that, if it's the second thing, if it's like they just were reassigned to your case, but they're not new as an immigration judge, it's neither a good nor a bad thing. It doesn't really matter. But if they're a new immigration judge, meaning they were just hired as an immigration judge, they just started that job within like the last year, then you probably won't be able to find statistics for them, approval rates. Because if you didn't know, by the way, there's a website you can go to where you can find the asylum approval rates by judge. Okay. But they won't have that data for some of the newer judges. But there is a way that you can get a sense, probably. It's not 100% accurate, but usually it's a pretty good guide as to whether they tend to be very, very strict and more likely to want to deport people, or on the other side, maybe a little more even and fair and even possibly even pro-immigrant. And that's what is their background, okay? Because historically, most of the immigration judges are former prosecutors with ICE. In other words, they came up and worked for a long time, maybe their whole career, as the people who are trying to do the deportations, the lawyer for ICE. ICE is part of the Department of Homeland Security. It's the part that arrests immigrants, and it's one of the entities that arrests immigrants, and their lawyers handle the deportation proceedings. So they're trying to deport people, and then very often they'll go on to become judges. There are fewer judges from like the private sector who are like me, a private immigration lawyer, and who are helping people to try to not get deported. But if you find out that someone is coming from being a private immigration lawyer, not a government deportation lawyer, there's probably a decent chance that they're likely to be maybe more fair and flexible than these former government lawyers who tend to often be of this mindset that is just generally anti-immigrant and they're inclined to want to deport people. Okay. So, how can you figure that out? If you Google the judge's name and Google the letters EOIR after their name, and like judge, you can find like the announcement. Because when the Department of Justice, which is what runs EOIR, which is the immigration courts, when they hire new judges, they publicly post like on their website, like, oh, we hired new judges. Here's the new judge. Here's where they're going to be. And here's a paragraph of like a biography about them. That's so if you Google their names, EOIR, you can usually find that announcement and you can see what their professional history is like. Okay. All right. Interesting question from RS on the Political Asylum Lawyers YouTube channel. RS says, if the officer, meaning asylum officer, did not grant your application and you had lawful status at that time, is it possible to ask the officer to revoke your status and refer you to court? So what RS is getting at is when you go to your interview with the asylum office and if you get a negative decision, if they say you are not eligible for asylum, at that moment, when they're making that negative decision, they look at what your status is. And if you do still have legal status, maybe you still have tourist status, maybe you have like a long-term, business status or student status, then they don't send you to immigration court. They just deny you. Well, actually, first they give you a chance to sort of try to change their minds in writing. You have 16 days to respond to what is called a notice of intent to deny, where they say, we intend to deny you for the following reasons. You have 16 days to write back to us and try to change our minds. So you do that, and then they look at it. If they still want to deny you, they look at your status again at that time. And if you still have status, they just say, denied, asylum denied. Nothing else happens, though. Nothing happens. You don't get put in deportation proceedings. You don't get put in immigration court. The government's not trying to deport you. You just continue on with whatever status you have for as long as that status is valid for. Now, I think most people think that's a good thing. They don't want to be put in deportation proceedings. Why? Because when you're in deportation proceedings, you might get deported. You're one step closer to possibly having to actually leave the country. But there's some people who don't want to do that. And it sounds from this comment like RS, they want to go to immigration court. Why? I'm guessing RS is like the other people, most other people who come at it from this approach. The idea is, no, I want another chance, because when you go to immigration court, you get another chance to explain your case, and the judge may decide that you're eligible for asylum. And recently, the immigration courts have had a higher approval rate than the asylum offices. So you probably have a better chance in immigration court. But RS sounds like you didn't get to go to immigration court because you had lawful status. So they just said denied, but they didn't send you to immigration court, but you want to go there because you think, you know what, I've got a good case. I want another shot at this. Because if you don't get that chance, you're not going to get asylum. Technically speaking, you can apply again with USCIS, but the chances of getting approved after having been denied by USCIS are extremely low. Okay. So what RS is asking, like, look, I want to get to immigration court. Can I just ask the asylum officer to like take away my status and put me in immigration court, send me to immigration court? No, they don't do that. Unfortunately, they won't do that. They by policy, they just don't, they don't do that. There's other ways to get into immigration court, but if you don't, once your status ends, you're out of status, you don't have legal status. Well, you could be put in immigration court, but you probably won't be unless you have contact with the authorities. And by contact, I mean like they arrest you. If you were just to walk into an ICE office after you lose your status, like let's say whatever you have now after it expires, if you just walked into an ICE office and said, hey, I don't have status, I'm out of status, would you please try to deport me? They probably will not. So there's other ways though that you can get put in deportation proceedings if you commit certain crimes that can get you put in deportation proceedings, but I don't recommend doing that. I'm not recommending that you commit crimes. Unfortunately, RS, the answer is like, no, there's not really a way to get put into deportation proceedings on purpose. Now, I will say people often do this. People often apply for, there's a lot of people who apply for asylum as a way to get an immigration court so that they can pursue a different kind of case called cancellation of removal, which is for people who have been here for a certain amount of years and meet these other conditions. Sometimes they can get a green card based on this, but it's really hard to get. And these people want to pursue cancellation of removal, but you can't apply to USCIS for that. You can only apply to an immigration court for that. And they want to get in immigration court. And so they file an asylum application, even if they don't have a case at all, or even if they're way past the 1-year filing deadline, because that's really like the only surefire way to get put in immigration court is to apply for asylum, get a negative decision, and while you're out of status and get put in immigration court. But that's largely considered to be unethical to file an asylum application under that circumstance if you really don't have any case at all and no real fear of being harmed. So yeah, that's just to me an interesting aside. All right. Wow. Okay. So Saeb says more than 8 years and no interview. I think, did we talk about this already a couple of days ago, Saeb, or last week? I'm sorry to hear that. That sounds really tough, man. That's hard. You are in a very strong position to sue the government to force them to give you an interview. Okay. If I were you, I would sue the government. And if you want our help with that, you should call us to schedule an asylum strategy session. That number is right above my head. Okay. On Facebook and YouTube, that number is right above my head. On and LinkedIn. On TikTok, go over to my profile and the number's right there. Okay. Call us and schedule an asylum strategy session so we can talk about suing the government, but also about how we can strengthen your case. Because I promise you, there's a lot that we can still do. Even though you obviously already applied, there's a lot we can still do to strengthen your case. Okay. We have lots of clients who hire us after they've applied. In fact, we had an asylum. My colleague Lori did an asylum interview today for one of our clients who applied 6 or 7 years ago. I think maybe actually it might have been 8. And we sued the government for her to get her interview in Miami, the Miami asylum office. And it worked. The government said, "Oh, we don't want to fight this case out to the end. We'll just give her interview." They gave her interview. It happened today. Um, and my colleague Lori said that she did great. We did a lot to help her to present, to explain her case on paper. We did a lot of work. We wrote a legal brief where we explained exactly why she's eligible for asylum. We helped her develop and get new additional evidence beyond what she had already submitted. We did practice interview sessions with her and gave her all of our best tips. And then my colleague Lori represented her today during the interview to advocate for her and help explain her case. And I think she's going to win. We haven't gotten the decision yet, but I think she's going to win. So you should call us. You should call us and talk about your case, how we can strengthen it and how we can force the interview. Okay. So Lucky Man says on Facebook, should I continue to file my asylum if I have a wife who will file a marriage for me? You should, yeah, you should I think that you should pursue an asylum claim unless and until you get a green card in your hand through marriage. Okay. Once you get the green card in your hand, then I would say it's okay to withdraw your asylum claim to stop it, but don't do it until you get that green card in your hand. That's what I think. Okay. All right. Nice. Yeah. So, okay. This is interesting. So I have a pending asylum case for asylum. And I'm not scheduled for an interview for like 6 years now. My spouse and I got divorced during the 6-year wait, and he's a dependent on my case. Is it still possible to file for his work authorization since he just came into the country and my interview is still pending? All right. So you got divorced, but he's included in your case as a dependent. No. I mean, to be honest with you, if you applied, if you have not told the asylum office about the divorce, then if he applied for the work permit, it would probably get approved because the people who are handling the work permits don't know that you're divorced because the asylum office doesn't, and the asylum office doesn't know that you're divorced. Therefore, no one knows that he's no longer like validly a dependent in your, he's not entitled to be a dependent in your case. So it would work. However, it shouldn't. So, under the rules, he is no longer entitled to be a dependent in your case, and he's therefore not entitled to get a work permit based on that case because he's not part of it anymore. Once you get divorced, he's not rightfully included in the case. So if I were you or him, I would not apply for it. But I don't know if you saw the beginning of this the conversation on the Asylum Answer show, but this is what I was talking about: is where someone gets divorced. The short and sweet version is if your ex-husband, wants to get asylum, he's not going to get it through you because you're divorced. So he needs to file on his own as a principal applicant if he's afraid of being harmed, and he needs to do it as soon as possible. Like ideally within a month or two of getting divorced. If this right now is the very first time that you're hearing about this requirement that he file within in a reasonable time, I guess what matters is when he hears it, not when you hear it. That can help a little bit in terms of the overall analysis of whether he filed within a reasonable amount of time. It can help a tiny bit, but yeah, he needs to do it right away. All right. On YouTube, Hadash says Zahir says, Brian, could my children benefit from a scholarship when they're under an asylum case with me? So I guess the question is, will is there any problem with them getting scholarship money? If that's the question, the answer is no. It's not going to. If they get scholarships, it will not affect your asylum case at all. It has nothing to do with your asylum case. But if the question is, are they eligible to get scholarships as people who are dependents in an asylum case? That's the different question, to which I don't know the answer. That depends on the actual scholarship itself and what the rules are for whether someone's status is whatever. I think they probably can. I think that they've presumably they have work permits and social security card, which is enough to get most kinds of things, like a driver's license. But it really is going to come down to just the specifics of that particular scholarship. Okay, so you got to check with the university or the foundation, whoever it is behind the scholarship, to ask that question to. All right. Up against time. I'm going to head out. Thank you for being with me. I'm going to go live in English on Friday, probably at 3 p.m. Central Time. If you speak Spanish, I think there's several Spanish speakers on here. I'm going to go live tomorrow on Thursday at about 3 p.m. U.S. Central Time. And that Asylum YouTube channel in Spanish is called Asilo Aprobado. For those of you on TikTok in English, go to YouTube and find me at Political Asylum Lawyers and subscribe there. Okay. Thanks for being with me. I'm Brian Manning. As always, it is a pleasure to serve you. It's an honor to serve you in your asylum journey. So thank you. And I'll